Well, hello, viewers and listeners to CHP Talks. We're here once again to discuss an issue important in our Canadian society. And we're here. I'm here with my Ontario president, Jim Enos. I'm the national leader of the Christian Heritage Party. Jim is the Ontario president. And we have a special guest with us, John Sikkema. He is counsel with the Acacia Group. And he has recently represented us as intervenors in a case in Guelph, the Guelph Right to Life case. So welcome to both of you. Thanks for joining us today.
Thank you very much. Good to be here.
Good to be here again.
Yeah. So we've had a little bit interaction with Acacia Group in the past with lawyer Albertos Paulizagopoulos that John works with, and we had a successful case with him. Jim knows a lot more about that, but we're going to jump right into this now and discuss the recent Guelph Right to Life case against the City of Guelph. So, John, can you give us a little background? What happened there? There was a ruling last week. It was beneficial, and you can tell us what we need to know to understand that case.
Sure. So the local Right to Life group, the Guelph Right to Life group, had successfully posted 3 ads on Guelph Transit, 3 respectful, civil, pro-life ads. One said, life should be the most fundamental human right, and had an image of a child in utero, obviously implying the right to life applies to the preborn.
Right.
Or in their view, should, right? They actually used the term should. And then the second one said, human rights should not depend on where you are. You can maybe guess the graphic that went with that, right? It was a child in utero and then a child in a woman's arms. And then the third ad was again an image of a child in utero. And then the caption said, "What about her choice?"
Okay.
Okay. Now the city posts these ads, so apparently doesn't think there's anything majorly wrong with them, but then it gets complaints. We don't really know much about those complaints, who they came from, but anyway, they get complaints and they send it to Advertising Standards Canada to review. Okay, and Advertising Standards Canada is an advertising industry body that companies will kind of voluntarily submit to what they decide. They're not a government agency. They don't have any legal authority, and yet the City of Guelph, which is government, decides to involve Ad Standards Canada in its decision making. Ad Standards Canada says that these ads are misleading because they refer to human rights, because they use the pronoun, they use pronouns in reference to the preborn, and they say, well, this implies humanity in the preborn, when they're not legal persons, they're not human beings under the homicide provisions of the criminal code. So it's misleading. And then a couple of the ads, the latter two, the one with the woman holding the baby and the one with the woman who's pregnant, and then the other one about what about her choice. They say these ads are also disparaging to women, right? So part of the ad policy is you're not supposed to post ads that are disparaging to any group, right? Which you can think of that makes sense in a way, right? You don't want to just have hateful ads around town that condemn this or that religious group or ethnic group or whatever. But they say these are disparaging to women because, well, on the one hand, what about her choice implies that a woman having an abortion deliberately deprives someone else of their choice, which they say is both false and demeaning to women. And then the other one, human rights should not depend on where you are, shows a visibly pregnant woman or a drawing of a visibly pregnant woman, and then they say that oddly that is misleading because abortions rarely happen that late, but also disparaging because it's disparaging to suggest that women routinely have abortions that late, as if it was necessarily saying that it's routine. And also bizarrely, why is this demeaning if you're okay with it?
And also the question is, nobody said, we didn't say anything, or the Guelph Right to Life didn't say anything about how old the baby was. Like, they're jumping to conclusions because of the image, but it could apply to a child of any gestational age, right?
That's right. That's the point. I mean, the point of that is human rights should not depend on where you are. And obviously to visibly represent that, they're just saying the point of birth is an arbitrary starting point for human rights. That's obviously what the ad's trying to convey. But anyway, the Ad Standards Canada took the view that that was disparaging and misleading. And then the city basically says, we agree. We agree with ad standards. We adopt that decision, and they took down the ads. And so the Guelph Right to Life group took them to court.
No, that's a judicial review. Is that the correct term for that process?
Yes, which it is what it sounds like. Excuse me. So when you have a administrative figure or a bureaucrat or even a government minister make a decision that they have the legal authority to make, and you think they made the wrong decision, right, out of line with the law or just unreasonable, you can apply to a judge, and the judge reviews that decision. It's called judicial review, and that's what they did. They did here.
So Jim, I know you were involved at the beginning here when the case came up. You came to us, the rest of us on the national board, and said, here's a case that we maybe should be involved in, and because we care about free speech, we care about the unborn. Here's a group that is struggling with a court case or with a decision that violated their free speech. Just do you want to say anything about that before we let John carry on?
Well, yeah, we didn't want our great victory in Hamilton to kind of go by the wayside. It's nice to bring it out and use it when it's going to help somebody else. And by helping others, we help ourselves. And so we were very glad for the victory in Hamilton. And so with an opportunity like this, it was pretty hard to turn down. But even then, we didn't just leap into it. We had to raise the funds, and we have wonderful members who stepped up to the plate and met the bill before we spent a nickel. So it's good members that allow us to do these kinds of things, because these things aren't free, and we have to pay John. He has to make a living. Obviously, that's only fair. And he does a great job, and he should be paid accordingly. So we're really thankful for members who are committed to causes like this and for opportunities when they arise. But I want to say this: we don't go out looking for a fight. We're not looking around the corner to see who we can fight with next. But at the same time, if a fight is to be had, if somebody wants to have one, we're not going to back down. Mm-hmm. We're ready to stand up for what's right, no matter the cost.
So you just touched on, and I don't want to spend too much time on it, but I know that you were intimately involved in the case in Hamilton, and the John's partner there in Acacia Group, Albertos Palazagopoulos, represented us there. Can you just briefly describe what that case was? It was a couple of years ago. Can you just tell people what that was?
So we had placed an ad. Hamilton was going through, and actually the federal government was going through all kinds of policy decisions around men who feel like women, who claim to feel like women, entering women's intimate facilities. And so Hamilton was considering a policy to allow men to enter into women's public washrooms, change rooms, and showers. So it was public debate. And so we said, well, we're going to put up an ad about that. We put up an ad, and it's had a picture of a man pushing his way into a woman's shower, it's a ladies' shower room or something like that on the door. And it just said, competing human rights, where is the justice? And we thought, well, that's a fair question. Yeah. There's two sets of rights going on here. Those who feel like they're women wanting to go in, and women who are women not wanting them to come in. So we thought that's a fair question. And within 3 days of the ad going up, which had been approved, the city took them down. In this case, it took them down without any complaints. They had 0 complaints and removed the ads. So that I don't want to say anything more, but other than in the end, when the court ruled, they used words like tyranny in talking about Hamilton. They talked about tyranny and so on. So, it was a very good ruling in that sense. It really shone the light on the kinds of things that governments are heading towards these days, and we're seeing it at all levels now.
Mm-hmm. Well, and so we won that case, and that's probably why when this case came up, we thought that our experience there might be of some benefit on an intervenor basis with the Guelph Right to Life, who, of course, we would consider as allies in the social causes that we care about. So back to you, John. We're just going to maybe get you to back up and tell us what happened last week when the court looked at the case with the Guelph Right to Life.
Yeah. So in a sense, it was a victory. So the court said that the city did not handle it correctly. The city basically adopted ad standards reasons, said ad standards is not a government body and did not consider the charter right to freedom of expression, right? And so the city has an obligation to do so. And there's no evidence in the record that the city can point to saying that they really considered how freedom of speech applies here and how they balanced freedom of expression with whatever other concerns they had about the ads. And so the court actually sends it back to the city. So the court doesn't say you have to run these ads. It's unreasonable not to run these ads. The court sends it back to the city and says, you need to consider freedom of expression when you are going to decide this. And you can't just, you can listen to ad standards, you can consider their view, but the ultimate responsibility is on you as a government body to make the decision and to consider the charter. And the court also says a couple of other things. They say, for one, and based on the CHP's intervention, that when it comes to the issue of are these ads inaccurate because they imply personhood, humanity, and so on in the unborn, when they would say Canadian law doesn't recognize that. And the court said CHP noted that there are differing views on when life begins. And I think implicit in that, given our submissions, is different opinions on when human rights begin and so on. And that's a legitimate debate in a free and democratic society, and that the city needs to consider that. They say it's a legitimate issue, a legitimate factor for the city to take into account and connect it to freedom of expression when, again, deciding, do we reject or accept these ads? And so it goes back to the city. I wouldn't expect the city to reject the ads again and go back to court after, in a way, losing. It's certainly considered a loss for the city, but it's not maybe as big a win as we would hope for, and that the court didn't say, this is, your reasons are unreasonable, and you have to post the ads. So a good case, a good outcome, not a total victory, I would say.
Yeah, well, the whole concept of opinion, freedom of speech, and the fact that people are allowed to have different opinions, contrary to in the past week, our prime minister talked about the people gathering in Ottawa as having unacceptable views, which they are expressing. That was
Mm-hmm.
not only they hold these views, but they're expressing them. So he's got an opinion that he had just expressed about others. And of course, we in the Christian Heritage Party do have an opinion about the humanity of the preborn child. When you say, what about her choice, and referring to the child, of course, the child in the womb is either a boy or a girl. And so it's not, not really dishonest to refer to the child as him or her. And of course, the child cannot make choices, really at the stage in the womb. But if they are, if their life is taken from them, they will have no opportunity to make choices in the future. So anyway, that's quite a thing when a government body decides that certain opinions are acceptable and other opinions are not acceptable. That's really not how it's supposed to work in our country.
Yeah, I was going to mention one point which caught me by surprise on the ruling. It was on page 6 up near the top. And this is the judge's writing. They're saying counsel. When they say counsel, they're talking about the ads counsel. Council was clear in its commitment as an independent body to respect the rights of advocacy organizations to advertise their position. Then it says, it was council's unanimous decision that the ad did not demean or disparage women who have had or are considering an abortion, nor did it undermine women's rights when facing unwanted pregnancy. The imagery in no way offended the standards of public decency. Did you catch that, John, in that ruling?
Yeah, so that's in reference only to the first ad. So just to refresh people's memory, it's tough to remember.
Oh, I see.
The first ad was life should be the most fundamental right. And then it was I think it was just a child in utero, or it's a woman holding an ultrasound photo. Okay. So that's the ad, and it says life should be the most fundamental right.
Oh, I see. Okay.
So that one, it said that's not disparaging to women.
Right.
And then the other two, so where you are, human rights shouldn't depend on where you are, an image of the pregnant woman, and then the other one about what about her choice, implying that abortion deprives the child of their choice and so on. I suppose you could apply the same logic to the first one and say, well, it applies that a woman who has an abortion deprives a child of the right to life, and therefore that's disparaging. I mean, by the city's same logic, or by ad standards same logic. But you're right. Ad standards does on the first one say, oh no, we think it's not disparaging. It's okay. And I don't know if that's out of an attempt to look reasonable. If they just say everything that any pro-lifer ever does is disparaging, when this is about as tame an ad as you can imagine. Yeah. Maybe they look less reasonable. And so they say, oh, no, it's not disparaging, but it is misleading. So I was going
to ask you, John, so the court said you have to go back and reconsider. So obviously the city can just now put on a little card show and come back and still say no to the ads. Let's say they say, we're not going to put them up, but we'll go through the Loyola test. We'll do all the balancing, but in the end, come on. They have an opinion already. They're going to frame their work around their own opinion. Do you think the ads are going to go back up?
That's a great question. I think you're right. They could do that. They could say, okay, say some things about the charter and freedom of expression and whatever, and then again come up with reasons for, and maybe even bolster your, the reasons of ad standards and say, oh, we actually have, complaints that show that some women were deeply offended, and so these are offensive, and we want a safe and welcoming public transit system that doesn't make people upset when they take the bus, and so they could just kind of pad their reasons and say, hey, we thought about freedom of expression. We take it very seriously, but this is, our decision is to not post the ads. That's possible, and we could be back in court.
So yeah, that's my step. So that's what I'm saying. So if they try to just frame their opinion, use their opinion to frame their rationale. Is that the next step? We have to go back to court then now and see what so they have to give reasons back why if they're not going to put the ads up, they're going to have to give reasons why not, correct?
That's right. They have to they'll give written reasons why they won't put them up. And
then Guelph Right to Life can look at it and say, you know what? No.
That's
and they have to go back again?
Yes, they have to go back to court. That's right. So I think it depends, on what kind of appetite the city staff have for this fight and what kind of legal advice they get. They might get advice saying, it's not a great idea to go back to court over the same ads when you've, like I said, this is a loss for the city. You've lost once. If you lose again, it's kind of maybe further humiliation. At least now they can say, oh, we kind of messed up, or we didn't stop to consider the charter. We relied too much on ad standards, whatever. So the easiest way out of it is to just post those ads for whatever the period of the contract was supposed to be, and just kind of let it go. But you're right, it's possible. So we'll have to see. There's another case already in the in the courts on the same issue. It's with Hamilton rejecting pro-life ads. So that one would probably get to a hearing and a decision before this one would. So on that same issue where the city has rejected the ads, given reasons, it says that it considered the charter. And so it'll go more to, is that an acceptable limit on charter expression, charter freedom of expression?
One thing that did trouble me in the ruling, well, I was glad that they had to pay $25,000 to Guelph Right to Life. That was nice to see. But one thing that was troubling was point 100. It says, as the analysis above makes it clear, it is far from a foregone conclusion that a city should be required to post the advertisement at issue on its buses. There are legitimate, significant competing considerations, and the city should exercise discretion in weighing those considerations. The court has tipped its hand.
Yeah, that's a great point.
That's an awful thing to write, I think. They told the court basically told the city they're on their side. Yeah,
I mean, there's points in the judgment, like I said, where they point to, the CHP says this and ARPA said that, and those are legitimate things you have to consider. But no, I found that disturbing as well, that at the end of the judgment, I think on the whole, the judgment seemed to be critical of Guelph. And so almost to maybe kind of tip the scales back. And I don't think they to be fair, this isn't necessary to do, but maybe to be, I don't know, to whatever the court's, kind of ideological bent is here, or these three judges. You're right. They signal at the end, hey, you have legitimate concerns about pro-life ads to consider. Like, we're kind of with you. And even at one point,
my question, what would the legitimate concern be?
Yeah, I guess they're signaling they don't decide. The court kind of mentions the different issues that are legitimate issues, but they don't decide exactly, should those be determinative. So I think they're signaling to the city that, hey, maybe accuracy, maybe disrespecting women, maybe harm of some kind or upset to people, maybe those are, real concerns. Maybe you should go get some more evidence on that. Maybe you should have some more complaints or some more impact statements from people who see pro-life ads and say how much it traumatizes them. Like maybe there's something there to say, kind of signal to the city, kind of pad the record on this and be prepared to defend yourself more. Maybe, but I shouldn't read that much into. You can read what you will into that. I think you're right. There's a signal there of we're sympathetic to the city. And earlier in the judgment, the court says we're sympathetic to how difficult this decision is. And I thought too, it's not a hard decision. These are very civil, very respectful, very tame pro-life ads stating very basic points. I mean, if you can't say life should be the most fundamental right or human rights don't depend on where you are, I mean, these are pro-life beliefs and talking points 101. If you can't say that, you can't be pro-life in a public place, in a public forum like city-owned advertising space. So I found that troubling as well, that the court's signaling this is difficult. It's not. In some cases it may be. I mean, I can see a judge saying, if you had an ad saying abortion is the vicious slaughter of a preborn child. Okay, well, now we're getting to the person's motives. Do we know that it's a vicious? I mean, maybe I'm not saying that should. I don't think that's false, but in terms of, okay, do we want that on billboards that kids walk past or whatever? There's a judge is going to have some more to think about. There is all I'm saying. Yeah. But these are not even really controversial. I mean, in the sense that they're not inflammatory. They're not.
They're very nice, very attractive. I've seen the ads. They're very nice, very attractive, and like you have to be ideologically driven to hate these signs. Like there have to be people who are fighting against this expression by Guelph Right to Life. It's because of a deep commitment to their cause more than anything else. You can't look at them and say those are hateful or disparaging, not at
Yeah,
all.
the Abortion Rights Coalition has resources and tries to get people to complain. So whenever a pro-life ad goes up in a city, the Abortion Rights Coalition is on it, and they're directing people to file complaints so that the city will have a reason to reconsider or take down the ad, right? So there are activists out there on this, and I think they often have a sympathetic audience within city governments. It's not really a secret that city governments tend to be generally fairly left-wing, right?
Mm.
Yeah,
Well,
in the Hamilton case, all 4 witnesses were invited by the city to be witnesses. None of them came forward. The city had to go find people. I mean,
Right.
they staged and they state all even their affidavits, their word for word complaints. All 4 used the same words. The whole thing was staged.
Well, we're coming to the end of our time here. Want to give each of you just a chance to anything that needs to be said that didn't get said already. John, before you even do that, I want to thank you for representing us, helping us to attain intervenor status. It's been a learning experience for us in the Christian Heritage Party, and we were glad to be a part of this case. You kind of got us to dig up some of our reasonings for the ads that we've run in the past, and really appreciate how you've represented us. But go ahead, Jim. Have closing remarks, and then John.
Well, the only thing I'm going to say is this: I'm glad to be part of CHP. I consider it a blessing, and we are on the winning team. I've had people say to me they won't be a member of CHP because they want to be a winner. How can you be a winner and be on the other side? It's impossible. You want to be a winner, get on the winning side.
Yeah, absolutely. And thanks, Jim, for bringing this to our attention so that we could get involved. So, John, thanks again for joining us today and for your work. What any final remarks that you want to be sure our listeners are aware of?
Yeah, I'm grateful that you were involved in the case. You were there to defend freedom in advertising, especially on issues that touch on, moral issues, but issues of political importance. You're a political party. These types of rulings affect your ability to communicate and to advertise as well. And I think it was important that you were there. And this fight is not over. Yeah. I mentioned there is another case on this where we're going to try to focus on not letting the city kind of slip out and get that reconsideration. The court does signal here that you raise legitimate concerns about debates around when life begins. We want to focus on that. We're going to have more fights to defend that freedom, to have that debate in public spaces. And this is a step. It's one stage, it's one battle in that bigger fight.
Very good. Thank you very much. John Sikkema, counsel with the Acacia Group in Ontario, and Jim Enos, our Ontario president for the Christian Heritage Party. Thank you both for joining me today. God bless you and keep up the good work.
Thank you.
Thank you. Thank you, Rob. Thank you, John.